So if you're in a mediation process or collaborative law, and you could do things in a way that would be more efficient, that would provide greater clarity, that would save you money in the long run, wouldn't you want to do that? My name's Ken Novenstern from Fredman Baken Novenstern, LLP, in White Plains and Mount Kisco, New York. And I do collaborative divorce, I do mediation, I also do litigation. And the litigation gives me a broader perspective on collaborative and mediation matters because I see those matters when they fail and are in litigation. And I recently had a case where instead of doing agreements, putting agreements in writing, in a mediation, the parties thought that they had entered into agreements. And my client, the husband in the case, spent hundreds of thousands of dollars pursuant to what he believed to be binding agreements. And then when the matter broke down and he was in litigation, he learned that those agreements had never been put into writing. They were not binding upon the parties. And so I strongly recommend and encourage you in the collaborative process, in mediation, to make sure that when you're talking to that mediator or you're talking with your collaborative counsel and you're working on an agreement to stop the clock or to sell the marital residence or to sell the vacation home, that those agreements get put into writing as clearly as possible and in a way that those writings will be recognized by a court if litigation takes place. My name's Ken Novenstern, and again, I would be happy to talk to you about these issues and the importance of agreements in collaborative and mediation and litigation. Agreements are ways to make any process more efficient.